All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning. It's nice to be with you at the on campus. And we have one case that is scheduled for submission. That case is Robert W. Milas versus Society Insurance and Angela Von Lander. Mr. Bribriesco, you may proceed.
Counsel. May I please report? Dr. Milas, a board-certified neurosurgeon, sent a contract over to Society Insurance. He promised to perform a specific surgical procedure for a specific amount. In exchange, Society Insurance would pay him that amount. Society Insurance received this contract. They had enough time to research it. 2 of their employees looked into it, and they signed. Dr. Milas performed a medically necessary neck surgery. It took decades of training and education to be able to perform, where he had to cut through his patient's skin, past the muscle, into the neck, right where the bones, the vertebrae. He fused them with tiny screws, and if he went just a little bit the wrong way, it could puncture the artery that fed his patient's brain. That is the delicate neck surgery that we're talking about. And he charged his customary fees, $14,325.87. Instead of honoring the contract, Society Insurance sent a check for $1,620.52.
You know, the pre-approval form that Dr. Milas, he created the form, and his word choice used the term estimate. Hypothetically, if he had encountered some complications during the surgery, could he have charged more than the $14,000 estimate?
And I think that's a very important question, because there are cases where the contract obligee or obligor are not satisfied with the results. And that's not this case. This case, everyone, by the testimony is really clear, is that it was a good result. And so that very much distinguishes this case, Your Honor.
Would he have performed the surgery if they had told him that they're only going to pay $1,600 and change?
No, he would not have.
Getting back to Justice Waterman's question, though, did Dr. Milas have the ability under this contract that you described, would he have been able to charge more than $14,000 if after the completion of the surgery he said, you know, it took longer, it was more complicated than I thought, and I'm going to charge $16,000? Could he have done that?
Not under this contract, Your Honor. We believe that this contract was for a stated fee.
Well, why does it say estimate?
I'm sorry?
Why does it say estimate then? I mean, I understand you,
Right.
you know, you say it was a fixed fee contract.
Right.
Estimate isn't a word that is synonymous with fixed, I don't think.
And that is true. What is helpful is in the rest of the contract is you have the specific surgical procedure, and then you have the ICD-9 code for the billing, and then the stated amount. And so, and plenty of time. So Dr. Milas, he has a small clinic, and he created this form. And so while I guess, you know, that one word might have been inartful, the jury looked at that, and they said, you know what, this is a contract.
Let me ask you a question, Mr. Bribriesco. Let's say, in good faith, the society people had a different view of the document that they were being asked to sign than Dr. Milas did. Dr. Milas viewed it as a binding contract to pay a fee. they viewed it in good faith as only an authorization to perform the surgery. The jury decides, no, between these two interpretations, as a matter of interpretation, Dr. Milas is correct. That would entitle Dr. Milas to breach of contract damages, but would it entitle him to fraud damages?
And I think what's important is what the jury should decide. And we're looking at specifically society insurance intent at the time of signing the contract. One of the fundamental law of evidence, or is that, I shouldn't say fundamental laws of evidence, what we submit is that the jury is the best to weigh credibility. And the jury, they didn't have to believe Society Insurance's employees. In fact, they didn't. That was the testimony at trial, was that we didn't have a meeting of the minds. And the jury was allowed to disregard and weigh that testimony.
I understand the jury decided that as a matter of interpretation, Dr. Milas' view of the contract was right. But that's a separate issue from whether the society representatives had a good faith belief that it wasn't a binding contract, isn't it? Aren't those two separate issues?
And that's why we're here, is because we wanted the jury to decide that issue, and they never got that opportunity.
Did the jury verdict awarding him the full $14,325 make your client whole?
No.
Why not?
Well, and there's a couple of different reasons, but the first one, Dr. Milas, who owns a small medical practice, so $14,325.87 means a lot to him. And to get that amount of money 3 years, he has to make payroll every 2 weeks. He has to pay for his lights. So all that would...
What elements of damage are available under a fraud theory that, apart from those you already got for the contract award?
Punitive damages is the big one.
That's what we're here about. Is there anything else?
Well, that's up to this court. But the specifics is he had to put his practice on hold.
Is there any other element of damage he asked for under the fraud theory, or is it just the punitive damage?
My understanding is there's a benefit of the bargain where there might be additional compensatory damages that be allowed, but mainly we're here because of punitive damages.
Well, let's hear about that benefit of the bargain just a little bit, because that might tie in with the merits a little bit. You're saying that you might be entitled to more than $14,000 some in compensatory damages?
It's a possibility, Your Honor. I didn't research it as much as the punitive damage issue.
Can you put a little flesh on this possibility and try to understand? I mean, you're saying it was a fixed fee contract, and now I'm hearing, well, we might have got a little more, and I'm struggling a little bit.
Sure, and honestly, I would concede that amount to just say it's all about punitive damages.
I take it you agree with me that on the fraud theory, the time that we're concerned about is at the time that the insurance company signed this document, right? I mean, it's a question of intent at that time, right?
Correct.
All right. And what evidence do you have that at that particular time, an agent of the insurance company had the belief that he or she actually was lying to your client? I mean, it's got to be fraud, it's got to be intent to deceive. I'll call it lying just to make it simple.
Sure.
At the time the contract was signed, for you to prevail, it's got to be a lie. What do you got?
Sure, we got testimony saying that that Angela Bonlander was the representative who signed off.
Right.
And so we have testimony from her saying that she never told Dr. Miles she intended on negotiating his fees.
Well, I don't understand that, but what evidence do you have that she, at the time she signed, was lying?
And maybe to use a criminal analogy is appropriate. So in criminal law, a prosecutor who is not required to have the defendant admit, you know what, I was lying. They could look towards circumstantial evidence to show that, and we believe there is substantial circumstantial evidence. Not only would we not have to I mean, and in that situation, it's beyond a reasonable doubt.
What about just the check that they issued, $1,620.52?
Yes.
How does that impact the expectation or the benefit of the bargain that was struck by the estimate?
Well, Dr. Milas did not get the benefit of the bargain. And the idea was with the fixed fees, he would be paid promptly. Whereas, and hopefully I've answered your
Well,
question.
how does that impact Justice Apple's question?
Can you infer intent to defraud from the fact that ultimately they only paid it, I mean, at first it was 1,000. Can we infer from that fact an intent at the time the contract was signed that there was fraud?
You can, we submit that the jury should be allowed to consider conduct after the time of the signing to look at the intent of what was going on in the employees of society insurance, and that would be an example of we believe that the jury could consider.
Was there any evidence of the practices and policies of the insurance company with other doctors?
What we know is that this was their society insurance's business practice, and it was a two-step practice. The first step was to send it to a cost containment vendor. And if the cost containment vendor didn't save society insurance money, the policy was offer the doctor a reduced amount for prompt payment. In other words, doctor, you're going to take less if you want to get paid now.
I mean, what I recall about the record, Mr. Bribriesco, is that Bonlander testified consistently that she's not an expert on medical bills. She wouldn't approve a medical bill in advance because she doesn't know what's the appropriate and necessary charge for a particular procedure. That's not her field of expertise, and she'd always refer it on. What's so fraudulent about that?
What's also is the circumstantial evidence that comes around. So Ms. Bonlander went to her supervisor, Sean Kelderman. And Sean Kelderman, and Your Honor, this is would be Appendix 363. She was asked under oath, the estimate represented pre-authorization, did it not, on what Dr. Milas was going to charge? And she said, yes. In other words, she went to her supervisor, and her supervisor said, or at least in looking at the evidence in the light most favorable to the plaintiff. Go ahead, I'm sorry.
No, and I didn't read that in the transcript. You're right, you quote that correctly, and that's not what, that's, as I understand it, that's what, you did get Kelderman to say that at one point in testimony, but contrary to everything else Kelderman said consistently otherwise, including on recross right after that, where I think Kelderman was asked, sorry to beat a dead horse, but did you agree, did society agree when Ms. Bonlander signed the document to pay a specific amount for the surgery? And the answer was no. So, you know, I agree there is that one admission that you extracted, but it does appear that other than that, these people were consistent that they didn't understand the document to be an agreement to pay a specific amount.
And the jury, and this is what it's all about, the jury said, you know what, we don't, they discredited that testimony and said, you know what, there was a meeting of the minds.
No, but I guess this gets back to what I was asking earlier.
Sure.
You could be right about the interpretation. In fact, the jury said you are right, and that's done, that's over. You were right about how the matter should be interpreted. But that doesn't mean that just because they took a different interpretation at the time, they're committing fraud. Otherwise, every time two people disagree about the meaning of the contract, the other party would be guilty of fraud, right?
Right, and we're not saying, you know, if there's a breach of contract because circumstances have changed, that's not this case. What we're saying is clearly that society insurance never intended on paying that stated amount of the fee. And And there's the business practice, the circumstantial evidence, all of that.
But I mean, in the healthcare field, most insurance companies never intend on paying the initial bill that the doctor submits, correct?
This is a workers' compensation insurance company, and Dr. Milas had no other contract with Society Insurance. And what's important is in the Court of Appeals, they said, what's the harm in asking for somebody to take less? This wasn't an ask. And now 53, it's a fax from KPN Services. And in that, it's a quote, it says, please review the resolution of charges, and if this meets with your approval to avoid further bill review and any audit reductions, please sign and return this agreement. So take this amount of money, or else. This is not an asking, this is a threat. Then, when Dr. Milas didn't take that amount, then they sent the check for $1,620.52. That's punishment. I'll reserve the rest of my time for rebuttal. Thank you.
Counsel, thank you as well. Mr. Cook, you may present your argument.
Counsel.
Good morning. Guy Cook, counsel for Applicant, Society Insurance, a mutual company, and Angela Bolander, an insurance adjuster for 22 years. To put it simply, what the appellant is trying to do here is make a breach of contract case into a tort, or to tortify, if you will, an ordinary breach of contract case. And it was mentioned by questioning of the appellant, when a contract is breached, the non-breaching party is entitled to place in the position that he would have occupied had there been performance. In other words, the benefit of the bargain.
Well, let me ask
damages.
you, Mr. Cook, let me ask you this question. Supposing someone makes an unqualified promise to pay medical benefits, and from a hypothetical, I ask you to assume that unqualified will pay medical benefits, knowing in the back of the mind that medical benefits didn't include everything, but it might be, say, limited by the terms of an insurance plan or something. Would that be fraud?
I don't
Unqualified promise, and I know we're going to get into that issue, but unqualified promise and trying to we're going to pay everything, and then knowing that the promise has got some qualifications in the back and that it might not be 100%. Now, would that be fraud?
Well, it certainly wouldn't be the facts of this case.
Well, would it be fraud? I mean, it'd be a contract, it could be a contract to start with, but if that person, at the time of the execution of the contract, knew there was going to be some adjustment on the back end, would that be fraud?
The answer, simply put, is found in the 7 elements of fraudulent
So,
misrepresentation.
I mean, it would be fraud, right?
If there's proof of scienter and intent to deceive,
Right.
which is lacking in this case. Because
Counsel, aren't those classically jury questions that go to the state of mind? Is this really an appropriate case for summary judgment?
it is an appropriate case for summary judgment. 5 judges, 2 district court judges, 3 court of appeals justices, including the newest member of this court, have all decided there was no genuine issue of material fact. And why? Because the facts are devoid of the skullduggery, the deceit, the intent to deceive, the trickery that comprises what fraud is. And there is no fraud here. There was no meeting of the minds. And what's important to appreciate...
Well, there was a meeting of minds, but, I mean, the jury said there was a meeting of minds in the contract, right?
Actually, no. What's not well publicized in the Court of Appeals opinion is this was a split verdict. The jury found that there was no contract between Angela Bolander and Milas. No breach, no contract. They did find, and it's inconsistent verdict, frankly, that Society Insurance had a contract with Milas and breached it. And so it's enlightening in a common sense, real world way as to how the jury saw this case. They heard Angela Bolander. They saw her testimony. They judged her credibility. And if they thought there was even the scintilla of evidence of fraud, deceit, it's hard to believe that they would have said no contract, no breach. So,
Let me ask you a procedural question, Mr. Cook. Your client obtained summary judgment on fraud before trial.
right.
But then at trial, there was evidence presented, there was testimony, I assume on breach of contract, and there was an effort to bring the fraud claim back into the case during the jury instructions.
Right.
So, do we review the trial transcript, or do we review the summary judgment ruling?
Well, I think there's two things in play here. Because when they attempted to bring the fraud claim back into the case, it was an effort to get punitive damages. That's what this case has always been about. Because as was illustrated in the questions of the appellant, the most that he could ever recover is $14,325.
I think he acknowledged when he was up here that that's really what the case is about.
Right.
But my question is, really, what's the record we review?
Was there a genuine issue of material fact at the time the summary judgment was ruled upon? That's, I think, where your focus is, as it relates to the fraudulent misrepresentation. As it relates to the question of the request to have punitive damages submitted, because appreciate that they also asked for that, then you're looking at the totality of the record, and of course, it's completely devoid of the necessary requirements under 668A for the purpose of submitting punitive damages.
What do you make of the deposition testimony? I mean, you've heard the discussion that we've already had, but it strikes me, and I want to give you an opportunity to correct my impressions, it strikes me there's some inconsistency in the deposition testimony. On one hand, on direct exam, Bullhanger testified X, and then the cross-exam would seem to be kind of Y. My first question is there an inconsistency there? And my second question is, does it matter?
Well, I'll start with the second question. It doesn't matter. But I would submit that there is no inconsistency. There's some inconsistency between Sean Kelderman and Angela Bolander, which was addressed previously by Justice Mansfield. Frankly, I think she misspoke because it was corrected later in her testimony.
Well, okay, so, I mean, I understand you say she may have misspoken. I'd expect to say that. But on the other hand, someone could say, well, isn't this interesting? I mean, she's got conflicting stories. She got prepared by her defense counsel. Is the jury entitled to credit her first approach to it? When you say, and I understand you say, she misspoke, but maybe the jury would think, she misspoke the second time. The first time we're going to credit.
Right. And that was a judgment that the jury had to make, but there's not only the rehabilitation on the cross-examination that I conducted, but there's testimony before that that was not spoken to earlier.
Well, this is summary judgment, you know. I mean, so all inferences are favorable to the non-moving party, et cetera, and it just seems to me you got a fleck, and at least a fleck, and maybe more than a fleck. But the fleck is, well, you've got some testimony viewed in isolation supports the plan. You have rehabilitation and other testimony that you say undercuts the statement that was made, but isn't a jury question? You understand my question? Yeah.
Right. So there's two things. First of all, this is trial testimony. This was not presented to the district court for summary judgment. But in the trial testimony at Appendix 361, she was asked, and when you receive in the work comp department a request for authorization for surgery, and you decide whether to give approval or not approval, what are you actually looking at? What are you trying to decide? And she answered at page 361, we're really just trying to make sure the surgery proposed is related to the compensable injury.
Yeah.
She says that before she answers this question about, so the estimate represented pre-authorization, and then her testimony is corrected after that. It's important to appreciate that society, frankly, was confused when they got this form from Milas. And why is he sending this? What is this? And Bolander takes it to her supervisor and says, what is this? What am I supposed to do with this? Well, it looks like he's asking for authorization for the surgery. Well, I'm not sure he needs authorization from us. Well, he's asking for it. Approve it. And so she signs and approves it. And the point of that is that for the purposes of submitting fraudulent misrepresentation, there has to be fraud and deceit and knowledge that what she's doing is false.
Right.
And there isn't. It's not false.
Well, let me ask you, I mean, she knew, of course she knew that the bill is ultimately going to go through this back-end process. No, that's not disputed. I take it's also not disputed that the back-end process invariably led to discounts, or is that not so? What does the record show on that?
Right. Let me say a couple of things that I should have said to begin with. Bad facts can make bad law. And there's some bad facts in this case. I mean, it's unreasonable that this insurance company sent him a check for $1,400. That on its face is unreasonable. Now, that was done by a third-party bill review company. And when they figured it out and realized that he should have been paid more, they sent him about half of what his bill was.
Okay, so she knew, I'm taking it brick by brick, but she knew at the time she signed the estimate that there was going to be back-end review that would at least likely lead to discount. I mean, is that fair?
Sure she did. And so did Dr. Milas.
Okay,
And that's why he generates this form. And frankly, if there's any scintilla of fraud in this case, why is there no examination of what this fax is from Milas? Is he trying to lay a trap for the insurance member? He's been a provider for 47 years. He has arrangements with other insurance companies. He knows that in the world of medical reimbursement, there are adjustments. And he sends this. Here's another fact that's really important. And it's two things. Bo Lander's testimony that she was only promising by her signature authorization is unrebutted. Unrebutted. And in her 22 years, she's never, ever agreed in advance to an estimated fee. Also unrebutted. But the other thing that I think is not well publicized in the facts of this case, and it's very noteworthy, it's not mentioned by the appellant, and that is in a subsequent proposal for a back surgery on the injured worker, Dr. Milas sent a different form. And in this form, it not only said that he was asking for authorization for the surgery, but by signing, you agree to pay the fee listed. And so he knew that there was ambiguity to start with. He knew there was no fraud. He knew there was no meeting of the minds. And he wanted to make sure that the second time there was no ambiguity. This is by Milas to the insurance company.
Well, Mr. Cook, I think you're correct in identifying that there's maybe an expectation that there be some adjustments, and I think the parties were addressing this through the concept of estimated numbers. But it seems like in this case that the adjustments were planned. They had a third-party person that would do that. And the adjustments were so deep that is it enough to give rise that it was fraudulent from the get-go, that they got the doctor to do a surgery that he would not have done had he known that he was going to be facing an adjustment of, I mean, it was adjusted to about 12% of what the estimate was, and then eventually raised up to about a third. Aren't those deep enough that it's some indication that this was all planned from the get-go?
No, because a mistake is not fraud. And that was a mistake by the third-party billing review company, which was later corrected, albeit after some many months. And there was a mistake in that process. But that happens after the fact. That doesn't happen at the time that the lender signs this.
So it wasn't like 2 years had passed?
Right. And that's what I mentioned earlier.
So
there's some bad facts.
Right out of the gate, they shoot the doctor a check for about 10% of what the estimate was, and then 2 years later they cough up a third.
Right.
Is that enough to at least allow the jury to consider whether they have this planned or laid out at the time they entered into the contract?
No, because it's the difference between, as I said earlier, deceit and fraud and a mistake. This was a mistake, not by Bolander, but by another entity that was hired to review the bills. And Milas knew that his bills would be subject to review. But let me get to what I think really matters. And even if Milas had prevailed in his resistance to summary judgment and demonstrated that there was in fact a fact question of fraudulent misrepresentation based on some inference, as you pointed out, Chief, on scienter and intent to deceive by this cutting of the bill. And the jury concluded that he, not only did he get past summary judgment, but he submitted his case. The jury concluded he'd proven all 7 elements of fraudulent misrepresentation. What is the result? The result's the same. Because all he can gather is the benefit of the bargain damages. Because the next step, he would have to prove punitive damages, the very high burden under Chapter 668, actual malice, willfulness,
Those like maybe the students or Hadley versus Baxterdale type damages.
Yeah, right.
Wouldn't there be an argument there that there was a little more, since he had to wait 2 years to get paid, and would have had incidental expenses and costs as a result of this breach?
I think that the scope of his damages would have been the benefit of the bargain, 14,325.87, and possibly some foreseeable, consequential, or out-of-pocket damages, which are not present here. It's not like he bought special equipment to do the surgery and didn't do the surgery. It's not like the example in the brief by the appellant that some arrangement to paint your house and don't go through with the arrangement and the painters bought the paint. So the scope of damages are the same, but for the submission of damages.
Let me follow up on the facts. My understanding of the record is there was the bill submitted for the $14,000, and the original offer back from this third party, not from society, was $4,600. Is that right? And then that was rejected, and then the third party came back with the $1,600. Is that the sequence?
No, it's just the reverse.
It's the reverse. Okay.
The small amount is first.
Okay.
Then there's a review. And the reason that happens, by the way, it's in the record, is on its face it seems unreasonable, as I've acknowledged, is that there was some confusion by the third-party billing company whether he was in a PPO, whether this was a double billing. They made a mistake in how to review that. They later tried to correct it and sent him another check which represented about 50% of the so-called estimate, which Milas never cashed either one of those checks, and then went to trial seeking to gain about another $7,000, which the jury awarded him. Although, as I pointed out earlier, there was a verdict in favor of Angela Bolander, the person who allegedly was engaging in this fraud. They found no conflict. Thank you.
You may sum up if you wish.
Sure. Again, what I want to say is this has always been a case about punitive damages, the attempt to tortify, breach of contract, and we submit that there is no evidence of scienter, of fraud, of intent to deceive at the summary judgment level, and certainly never at the trial level when the jury had the opportunity to judge the credibility, look at this woman, Angela Bolander, and see if her conduct warranted fraud. But even as I mentioned, had there been a submission of fraudulent misrepresentation and the appellant had succeeded, the scope of the damages would be the same unless he could prove by preponderance of clear and convincing evidence that the breach of contract constituted willful and wanton disregard for his rights.
Well, if they lied to him, don't you think they've got a case of willful and wanton misconduct?
Not every breach of contract is a lie.
Yeah, I understand, but if the conclusion is that there was a lie.
It might be the first step in that process, but I don't think in and of itself it warrants submission of punitive damages, showing willful and wanton disregard, some malice, some ill will, some hatred, personal spite. Those are the type of things that justify punitive damages. A false statement, you've called it a lie, the same. A false statement.
If the record shows, and listen, I understand we spent a good bit of time on whatever, but if the record shows that someone lied to the other party about compensation and offered an unqualified promise to pay, wouldn't that be enough to get a punitive damage instruction?
In and of itself, I would say no. I think there has to be proof of actual malice. I think there has to be personal spite, hatred, ill will,
Reckless
willfulness,
disregard?
wanton disregard. I think it's a higher standard under 668. But in this case, there was no false statement. And I think it's really important, and I'll close with this, that we're not talking about this in hypothetical. The jury saw Angela Bowman. They listened to her testimony. And if they thought that she had lied or engaged in deceit, it's unreasonable to believe that they would find that she didn't breach a contract or have a contract. That would be the first step in showing some animus towards her conduct. Thank you.
Mr. Cook, thank you as well. Mr. Bribriesco,
Thank you.
present your rebuttal.
Yes, I want to start off by making sure answering all of your questions.
I have a question for you. I see this as a very, very important case because we live in a world where medical expenses are significant. There's adjusting going on all the time. It's a huge concern in our state and across our nation. And so we're talking about fortifying what have always been contract issues, and then of course takes it into a different arena, including punitive damages. Shouldn't we have a lot of pause and concern about doing that when it's such a broad and pervasive and important issue for everyone?
I would just ask that at the same time as I was taking contracts in law school, I was also taking torts. And the intentional tort of fraud has been around for a while. And those elements protect us from it tortifying of contracts.
But does it fit into the medical arena and the way we are, the state of affairs with billing of medical costs?
I think it has an impact even bigger than the medical field, because we're talking about a business practice where I can lie to you under a contract, whether it's to paint your house, to fix your car, to do whatever, then ask you to take a smaller amount of fees. And then if you don't, I can send you less money and hope that you never take me to court.
All right, the lie that we're talking about is the language that your client wrote, that their client, that Mr. Cook's client signed, right?
The representation, Your Honor, is the signature.
Right, but the lie is the language above the signature, right?
Where it says, this is how much I charge, and this is how much...
What your client wrote was, per your instruction, signature from representative at Society Insurance will be the authorization for surgery. That's what your client wrote, right?
That is correct.
And they picked the language, right?
Yes, Your Honor.
And they picked clearer language the second time around with the following surgery, right?
Fool me once, shame on me. Or shame on you, right? Shame on you. Fool me twice, shame on me.
Let me ask you a question about the record. I just looked at the appendix.
Yes.
Of course, now this is the problem with the iPads. I'm looking at appendix 229 and 230, and it does look like maybe I was right and Mr. Cook was wrong, that there was an offer within a few weeks of the surgery to settle the charges for $4,604. Is that correct?
That's correct.
And then your client turned that down, and then it was like it went downhill from there.
Yeah.
Then they came back to the $1,600. Am I correct?
That's correct.
Okay.
Is the clarifying language in the later form an admission that the form at issue today was ambiguous?
I don't think so, Your Honor. I think what it does is it just, we're looking at the intent of Society Insurance. And that's, I believe that's why we're here. Where the terms, the jury already decided, and it was not appealed by Society Insurance, that there was a meeting of the minds. And so we're looking at that intent. And so as far as an admission, we believe there's many admissions that show substantial evidence.
I have a question I'd like to ask. On the estimate, I only look at this document. That's kind of what this case is about. I can't get beyond the fact that, as Justice Mansfield said, to your client's words, he wordsmithed this document. He's the one that chose to put this before the insurance company. And I was hired by, and I got to take my pick which side to represent as a lawyer, and this was the document given to me, and I had to go to court with it to try and push it. The very top category, estimate, a proposed elective surgery. So it's the surgery that seems to be the focus of this document, not the box, the surgery. They're talking about estimate of proposed surgery. They give the types of surgery, and they do have the amounts. And then the very bottom, signature will be authorization for surgery. Those are squishy words. When you're talking fraud, don't you need more than squishy words?
The background is Society Insurance lost an application for alternate care. They lost. And Dr. Milas was authorized by the Iowa Workers' Compensation Commission. And then we can look towards the testimony, not only at summary judgment, but after we did a motion to conform with proof and offer of proof, we look towards the fact that the idea that an adjuster would authorize a doctor whether to perform a surgery or not, I think if you look at the testimony, he said, that would be ridiculous for you to pick. You know what, instead of going with a laminectomy, I think you should go with the fusion at that level. And that background we take into this contract. The reason why Ms. Bonlander took it to her supervisor, at least looking at the evidence in the light most favorable to the non-moving party, was because she knew exactly what Dr. Milas was asking for. And if she were confused, and which she could have simply not signed, or she could have said subject to bill review, or she could have turned in that contract to their bill review, and there would be a turnaround time of 5 to 7 days, well before the surgery, and sent it to Dr. Milas. There's so much evidence. There's so much evidence when we look at fraud. I just invite the justices to look at that evidence and not just to the four corners of the contract, which the jury already decided. In summary, I think this is a very important case. While Dr. Milas was paid only 10% of what he was promised under the contract, the anesthesiologist who was in the same room doing the same amount of time was paid more than Dr. Milas. Dr. Milas had to hire an attorney and go through this process while struggling to keep his clinic alive for that $14,325.87. When you compare that to what this business practice, for as all I know, Society Insurance is the only person who does this type of business practice. This business practice brought them millions of dollars in that same year. This case is important. Thank you, Your Honor.
Bribriesco, thank you as well. Mr. Cook, thank you again. The case of Milas versus Society Insurance is now then submitted to the court.